Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. This one's gonna be a little bit different because I'm in a different vehicle and I don't have the same phone mount that I have in my car. Today I'm driving our truck. It's a Ford F-250. I have to go register it and I've got to run around the court, so I'm going to be right down the street from the license office. In between cases, I'm going to run down and get this thing properly registered. Not that it isn't properly registered now. I am legal to drive it. But, so we got to do that, which means I'm burning gas. I don't like burning gas. I really like the electrics. But today, what I'm wanting to talk to you about is, there's been a lot of consternation over a recent case where the discharge of a union employee for using marijuana in his off time, not being impaired at work in Missouri, was upheld. And there are a lot of people that are upset about that, and I can understand they're being upset. However, the issues, and you have to understand where we are in Missouri, okay? Our constitutional amendment, Amendment 2, that is now Article 1, Section 14 of the Missouri Constitution, does not protect medical marijuana cardholders from being discharged from their employees by their employers for using medical marijuana. Doesn't protect them at all. The ADA does not protect, the Americans with Disabilities Act does not protect medical marijuana users from being discharged by their employers for using medical marijuana. The medical marijuana in Missouri is not a prescribed substance. It cannot be prescribed anywhere in the country because of its federal scheduling. The federal scheduling states there is no medical purpose for medical marijuana. Yes, I just said that out loud, and almost with a straight face, solely because of the sheer stupidity of that. But understanding that is key. What you have is not a prescription for medical marijuana. It's a certification. The doctor is certified that your condition meets the requirements in statute. Okay? The doctor is not saying that they are prescribing medical marijuana to you. That is a completely different situation. And I think would inculcate a different process on behalf of the medical professionals. So, while you have been certified to comply, that your medical conditions meet the requirements of the Missouri medical marijuana constitutional requirements, that is not a prescription. So as for employers and the ADA, while you may have a right to use medical marijuana, that does not extend to protection from discharge. Additionally, Missouri is an at-will employment state. An employer can fire somebody because they don't like the way their hair is parted that day. It's silly, it would be stupid, and I imagine it's probably somebody who has done that, but you can be fired for any reason. In the case everybody's talking about, that was a union employee. Now, union employees have different safeguards, and their safeguards are backed by federal law. So, that's a different situation than your average everyday employee in Missouri. Now, for the union employee, the employer has to follow the union contract and work with the union regarding grievances. They have to consider it, they have to listen to what the union has to say. And in that case, and I'm not going to get into the guy's name or bring up any more bad press. The guy's got enough stuff going on. He doesn't need it. He's got to find a new job, man. In that case, he was a union employee. He was out of work for 45 days for medical reasons. And the union has a contractual agreement with the employer that if you're out of work for more than 30 days, you have to have a drug test when you come back. So he submitted to the drug test, and he tested positive for THC. Not acceptable per that contract. However, the employee also did not have a medical marijuana card. Quite frankly, in that case, with the union contract, he would have had more protections than the average person, the average employee in Missouri. Sorry, I'm attempting to turn my cruise control on. So he would have had more protections than the average employee in the state of Missouri. Okay? And very likely, had he had a medical marijuana card, there is a valid argument that he may not have lost his job. So that's something that you have to consider. I'm going to wrap this up here in just a moment, but before we get into our final thoughts, please hit like and subscribe. It is important. It helps us spread the news to other people that are interested in these topics. Additionally, if any of you have used our firm, we wouldn't mind if you gave us a review on Google at Nolan Mulford Blue. But the thing you have to remember in this is you are not protected under our current law as a medical marijuana user or as a God, now that I'm shooting a video, the road noise is horrible. I miss my nice quiet electric. As a medical marijuana user, you're not protected by the state constitution. You're not protected by the laws we passed that authorized you and granted you the right to use medical marijuana. Okay? So, even with the protections we have, you're not protected. In the case that everybody is upset about, that employee very likely would have been protected under his union contract had he followed the requirements of his employment. Had he worked and communicated with HR, he very likely would not have been terminated. So that's a separate concern. But as for right now, yeah, if your employer or prospective employer is going to do drug testing, you got to clear the medical marijuana card with them in advance. You need to talk to them, make sure. If it's going to be a problem, then you have a decision to make. But it is unlikely that you're going to be successful in a wrongful termination action in Missouri if you are discharged because you are using medical marijuana. All right, again, hit like, subscribe, thank you, and I will be talking to you all again real soon.